Good morning, Your Lordship.
Just wait. Yes.
Good morning, Your Lordship. Of Advocate Gary Raimondo Lege Lobate, the lead defense team, in the presence of my learned colleagues, Advocate Kurulwal Kur, Advocate, in the presence of Advocate Kurulwal Kur, Advocate Anis Tombe, Advocate Deng John Deng, Advocate Ornyang Kir Ornyang, representing women in our side,
thank you.
in the presence of the 8 accused persons, 8. Thank you.
Thank you. The session is for today is the decision on the 2 objections, the one of the defense and that of prosecution. Thank you.
Okay, good morning. Let's go direct to the decisions, and I'm going to read it out. On the 1st of September 2025, the President of the Supreme Court and the Chief Justice of the Judiciary of South Sudan constituted this special court to try criminal case number 1533, 2025 for Nasser incident, March 2025, against accused person under sections 48, 50, 52, 61, 62, 65, 64, 65, 66, 67, 70, 71, 72, 75, 76, 206A and B, and 239 of the Penal Code Act 2008, and also sections 15A, B, and 16 of Anti-Money Laundering and Counter-Terrorism Act 2012, amended. On 22nd September 2025, the defense presented to the court an objection called preliminary objection. The title, Objections on Lack of Jurisdiction of the Special Court to try the first Vice President and the 7 others accused persons. That may be summarized as follows. Number 1, supremacy of revitalized agreement. And number 2, jurisdictional and procedural objection. Number 3, counter objection on the appearance of private advocates as part of the public prosecution attorney's team. As for the supremacy of the RI revitalized agreement, the defense cited Article 8.3 that says this revitalized agreement shall take precedence over national legislations and existing agreement to the contrary, and in the event that the provisions of national legislations or previous agreement conflicts with the terms of the agreement, the provisions of this agreement shall prevail. And that the revitalized agreement 2018 provides under 5.3.1.1 for the establishment of hybrid court for South Sudan. This court is independent and established by African Union Commission to investigate and prosecute individuals bearing responsibility for violation of international law and applicable South Sudan laws. Committed from 15 December 2013 through the end of the transitional period. Nasser incident is a ceasefire violation, and therefore it falls within the jurisdiction of the hybrid court. Article 17 of the revitalized agreement 2018 that should be adhered to. Read together with Article 5.3.1.2 and 5.3.2.2. In addition to Article 201A 7A, B, and D of the Transitional Constitution 2011 as amended. Furthermore, the defense mentioned that Article 9(3) of the Transitional Constitution of the Republic of South Sudan 2021 as amended provides that all rights and freedoms enshrined in international human rights treaties, conventions, and instruments ratified by or acceded to by the Republic of South Sudan shall be an integral part of this bill. So, trial of the accused persons disregard and alter-verse and unconstitutional. The defense also raised an issue of jurisdictional and procedural objection on the constitutional immunity of the first vice president, citing Article 103, 104, 2 of the Transitional Constitution of the Republic of South Sudan, 2011, as amended, read together with Rules 62 and 63 of the Transitional National Legislative Conduct of Business 2013 as amended 2021 that provides that the first vice president shall not be subjected to criminal proceedings while in office, except upon removal of immunity by 2/3 majority of all members of the National Legislative Assembly, and in accordance with the Rule 62 and 63 that provides that the provision of 62 shall, with the necessary modification, apply in respect of the first vice president and vice presidents. This raises questions as to when does court become competent. It is when it is properly constituted as regards yes, it is properly constituted. The subject matter is within the jurisdiction of the court, and case is put before the court based on due processes of law. This court is defect in its competency, since the President of the Supreme Court has no power to establish it before to establish it has no power to establish it before provisions of the Transitional Constitution 2011 as amended, Article 103, 104, 2, and provisions of the Transitional Legislative Assembly 2013 as amended 2021, Rule 62, 63 are adhered to, and also lack of resolutions that shall have been passed by the 2/3 majority of members of Transitional National Legislative Assembly as amended. The arrest and detention of the accused were carried out without due process of especially lifting of the immunity of the first vice president. And therefore, the proceedings are unconstitutional, unlawful, and void. The accused person shall be immediately released, plus any other reliefs deemed fit by the court. The response of the prosecutions may be also summarized as follows. Number one, that provision of revitalized agreement 2018 and transitional constitution 2011 amendment number 6 2020 limits jurisdiction of hybrid court to international law crimes and crimes under relevant South Sudan laws, including gender-based crimes and sexual violations, when and if established. There is no conflict between the revitalized agreement and national law in this case. The two are distinct. Number two, that it is only the president who is immune during his or her tenure of office, according to Article 103(1) of the Transitional Constitution 2011, Amendment number 6, 2020, and Rules 62 and 63 of the Transitional Legislation, Conduct of Business Regulations 2013, Amendment 2021. They deal with the removal if the Vice President and not trial, dealing with the removal of the Vice President and not trial of the same, since that does not override provision of the Constitution. Number three, that according to Article 123(a) of the Transitional Constitution 2011 as amended, the Judiciary Act 2008, Section 7F, and the Code of Criminal Procedure Act 2008, Section 16(4), give the President of the Supreme Court powers to constitute a special court to try any person accused under Chapter 5 and 6, inclusively, of the Penal Code Act 2008, and a written order for establishment of a special court as required under Section 44 of the Code of Criminal Procedures Act 2008. Therefore, the special court has been duly constituted in accordance with the law, and it follows that the court is legitimate. Number four, that the Minister of Justice has power under Section 45 of the Ministry of Legal Affairs and Constitutional Development Organization Act 2008 to engage any advocate outside the ministry whenever necessary. Each party stood its position in its response and comment to pleading of another. And according to that point for discussion and determination may be summarized as follows. Number one, supremacy of the revitalized agreement 2018 as embodied into the Transitional Constitution 2011 Amendment number 6, 2020. Number two, President of the Supreme Court has no power to constitute a special court to try national incidents crimes. Number three, immunity concerning the first Vice President who was not lifted when he was arrested. Number four, a special court established by the President of the Supreme Court is unconstitutional. Number five, that private advocates who are on the side of or within the public prosecution have no legitimacy and should be sent away. And the two advocates within the defense teams lack or have no license and should be told to go outside the court or sit with the audience over there. Now, it is evident from the submissions that main points for the determinations are to be discussed as follows. Number one, reading warrant of the establishment of this special court and argument of defense and prosecution, the court believes that there is no overlapping of jurisdiction between its competency and the one of hybrid court for its twice offenses committed in Nasser incidents in March 2025, and that hybrid court have jurisdiction within with respect to genocide, crime against humanity, war crimes, and other serious crimes under international law and relevant laws of the Republic of South Sudan, including gender-based crimes and sexual violence, as provided for in the Transitional Constitution of the Republic of South Sudan, 2011 Amendment number 6, 2020. The Constitution made it clear that the hybrid court shall be independent and distinct from the national judiciary in its operations and shall carry out its own investigations. The hybrid court shall have primacy over any national court of the Republic of South Sudan, of course, when a conflict of law arises. So, the High Court has jurisdiction to investigate and prosecute in respects with individuals who violated applicable laws of South Sudan, which are relevant according to Article 5.3.1 and 5.3.214 of the Revitalized Agreement of 2018. It is obvious now that those applicable laws of South Sudan and its other relevant laws have not been identified or named in the Revitalized Agreement on the resolution of the conflict in the Republic of South Sudan in 2018. It follows that failure of the Revitalized Agreement itself to specify, those applicable South Sudan laws and relevant laws of Republic of South Sudan made it difficult to understand the specific jurisdiction of the hybrid court itself in regards to the laws of the Republic of South Sudan, which fall within its jurisdiction, domestic laws. The hybrid court for South Sudan have not yet been established, and it is not clear when it will be established. National courts of South Sudan are operating and exercising their constitutional mandate according to the provisions of Article 122, sub-article 1 and 2 and 4 of the Transitional Constitution 2011 as amended, as long as they have not been suspended or withheld from doing their work by the hybrid court, which is in actual fact is not existing, since the national and hybrid court are independent according to the provisions of the Article 5.3.2.2 of the Revitalized Agreement 2018. Those special courts enjoys jurisdiction to try this case according to the Constitution 2011 as amended. Number 2, as for the jurisdiction and competency of the President of the Supreme Court to constitute a special court to try Nasser incidents, offenses, the law is clear that he or she has the power, bearing in mind the separation between hybrid court and national courts, as stated above. To explain, the President of Supreme Court of the Republic of South Sudan established Nasser Special Court according to provisions of Article 124, 122.4, 126.2, G3, and 127.1b of the Transitional Constitution 2011, in addition to the provisions of Section 16.4 and Section 44 of the Code of Criminal Procedure Act 2008, and Section 11(3)(7)(f) of the Judiciary Act 2008. Therefore, the court has jurisdiction and competence to try the accused persons, since the wordings in the Revitalized Agreement 2018 and Transitional Constitution 2011 Amendment number 6, 2020 says that the word that's from 15th December through the end of the transitional period is not meant to hold back states' hands in addressing crimes, even if the hybrid court is active. The national courts have the jurisdiction and powers to prosecute offenses in the territory of the Republic of South Sudan. Therefore, it is the evidence that is the stickyard to prove whether the subject matter of the trial belong to the hybrid court or national court. Number 3, concerning the lifting of immunity of the first vice president raised by the defense based on Article 103, 102 of the Transitional Constitution 2011 Amendment number 6, 2020, and Rule 62 and 63 of Transitional National Legislative Assembly Conduct of Business Regulations 20 Amendment 2021, which provides that the first vice president should not be subjected to criminal proceedings while in the office, except upon proper removal of the immunity by a resolution passed by 2/3 majority of all members of National Legislative Assembly. The prosecution replies to these claims in their submission. In pursuant of Article 106, 104, 103, and 102, the Transitional Constitution 2011 has amended and provisions of 62, 63 of the National Assembly Code of Business, Article 103.1 confers constitutional immunity upon the President of the Republic of South Sudan only. And Article 104.2 of the Constitution is dealing with appointment and removal of the first vice president Provision did not expressly or directly mention immunity of the first vice president and other 4 vice presidents. As for the provisions of rules 62, 63 of conduct of business, stated above deals with impeachment of the President of the Republic, and Rule 63 of the same deals with the removal of the first Vice President and the 4 Vice Presidents. The two rules cited by the defense do not talk about constitutional immunity of the first Vice President, because the constitutional immunity is created or granted by the Constitution as the supreme law of the land in the hierarchy, according to provisions of Article 3(1) of the Transitional Constitution 2011 as amended, which reads, "This Constitution derives its authority from the will of the people and shall be the supreme law of the land. It shall have a binding force on persons, institutions, organs, and agencies of government throughout the country. Therefore, provisions of the National Assembly Code of Business 2013 as amended is a subsidiary legislation. It governs the conduct of business of the Assembly, which is subordinate to the Constitution 2011 as amended, and therefore it doesn't create or grant constitutional immunity to anybody in the country. On the contrary to the Constitution, for the above mentioned reasons, the first Vice President does not have constitutional immunity, according to the provisions of the Transitional Constitution. Therefore, the objection is rejected. Number 4, whether the special court established to try Nasser incidents is unconstitutional or constitutional. The Transitional Constitution 2011 Amendment number 6, 2020 says Judicial Services Commission shall undertake appropriate judicial reforms and restructuring of the judiciary during the transitional period. But the structure of the judiciary remains as it is under Article 123 of the Constitution above. Other courts and tribunals are part of the structure of the judiciary as provided for in Article A of the stated Constitution. Section 16 of the Code of Criminal Procedure Act 2008 provides for special courts, and it's specifically subsection 2 of the above provides that the President of the Supreme Court may convene a special court to be presided over by a High Court judge or any other senior judge, to be assisted by 2 accessories for the trial of tribal or sectional conflict and dispute involving capital offenses. Reading those provisions with the Judiciary Act 2008, we can say this is special court for Nasser incidents is constitutional and therefore has the competency to try the case as stated previously. Number 5, advocates here and there. Both parties to the case objected to certain advocates found within this or that team. Prosecution and defense. Prosecution's objection is that Advocate Deng, John Deng, and Warnyang shall not be allowed to be within the defense team because they did not renew their license according to the law. Advocate Act 2013. Failure to renew the license at the end of January every year, the license shall be deemed to have been suspended. The defense is not denying that, but saying they were deliberately denied to do so by the Bar Association. Since advocates are tasked to defend legal and interests of their claims, to prevent injustice as guaranteed in the national and international instrument, the defense prays the court to reject prosecution objection, considering the period from January, from the end January up to now. It is a long time. The advocates in question would have tried forcible means to renew their license, including going to the court to settle the matter. Appearing before courts without valid license violates Section 26 of the Advocate Act 2013. It follows that joining defense team without informing or even taking permission from the court may not be upheld, since it is a constitutional requirement under Section 136(2) of the Transitional Constitution 2011 as amended, among others. The advocates shall observe professional ethics. The only way now for them to rejoin the team is to remedy their position by using Section 102 of the Code of Criminal Procedure 2008 and seek out sanction of the President of the Supreme Court to appear before this court. As for the private advocates with the prosecution team, defense objection has no merit, simply because it is obvious from section 45 of the Ministry of Legal Affairs and Constitutional Development organization that the minister may engage, advocate, or make use of legal expertise from outside the ministry whenever necessary. This is his or her discretion powers. Therefore, the objection is refused, and the decisions or the orders of the court are as follows. Number one, objections of defense teams are overruled. Advocates Deng John and Kir Warnyang are ordered to leave defense team and seek sanction of the President of the Supreme Court to return back. Private advocates within the prosecution team are allowed to continue. Thank you. Sit down, you finish. And after this, disposal of these two objections, now we proceed to listen to the prosecution's number one witness, who is the investigator.
May it please this court, I would raise a procedural issue under section 224 of the Code of Criminal Procedure. And the procedure issue is that we are, as a prosecution, supposed to provide before this court our prosecution opening speech.
You are correct. Please proceed.
Thank you, my lord. Honorable Court,
we are still seeing the advocates who have been sent to go. Please let them go, and you are advised that you go to the Chief Justice and get his sanction and come back. We are very clear, all right? Thank you. Please go. Continue.
Thank you, my lord. Honorable Court, this is the prosecution opening statement of speech. In this case of Republic of South Sudan versus Port Kang Chol and others, criminal case number 1533 of 2025. Honorable Presiding Justice and distinguished members of the bench,
don't be running. Just give us a chance to write. Yes. Opening speech.
This is a prosecution opening speech. We are going to give you copies of the same, and I will try to be as slow as possible as well, my lords. So this is the opening speech. Republic of South Sudan versus Port Kang and others. Criminal case number 1533 of 2025. Honorable Presiding Justice and distinguished members of the bench, with due respect and on behalf of the Republic of South Sudan, allow us to present this prosecution opening speech. On the 3rd through the 7th of March 2025, in Nasir County, Upper Nile State, the people of South Sudan and the world witness the gravest crimes that strike at the very heart of our constitutional order, endangered our national security, and traumatized and inflicted immeasurable suffering on the people of South Sudan. The government military garrison in which Yardiu, Nasir was attacked and overrun by the White Army militia. The government forces that surrendered on their own and those that surrendered on the persuasion of the fifth accused person, Dr. Riek Machar, including the late David Majur, who was to be evacuated by a UN helicopter. Those injured and those captured alive were rounded up and executed at point blank. The dead were dragged around and others dumped into the river and others left to rot where they were executed. My Lord Justices, on April 20th, the South Sudan People's Defense Forces, SSPDF, regained the control of Nasir Town and Which Yardiu military garrison. At Which Yardiu garrison, they were welcomed by the dry bones of their slain comrades. An apocalyptic scene comparable to the biblical phrase of Valley of Bones. But here, my lords, it was a barbed wire garrison, a plain land of bones overlooking the silent and grieving river. The prosecution stands before you today on behalf of the people of the Republic of South Sudan to seek justice for these heinous crimes committed by the accused persons. My lords, justices, this case is about individual criminal acts or omissions or responsibilities of the accused persons. I emphasize individual criminal acts or responsibility of the accused persons. The accused persons are namely Port Kang Chol, Lieutenant General Gabriel Droblam, Mampal Duor, Garawich Lampoch, Dr. Riek Machar, Brigadier General Camilo Gadmichael, First Lieutenant Mading Riak, and Lance Corporal Dominic Gadgok Riak, who are present before you here, and others who are at large, namely Lieutenant General Peter Tokchuo Luak, Major General Dilin Care Cholkuj, Major General Peter Ruach Wibiem, Lieutenant General Yei Dak Wiu, Major General William Deng Bom, Kang Makana, Major General Kong Miang, Kwang Terjes, Garawich Liam, Biel Wiu, James Galwak Liu, Brigadier General Hogdor Chuol, and Pal Mai Deng. My Lord Justices, investigations were conducted of over 100 people, and the rest were released. And only these were the ones the prosecution has presented before this court to have been found culpable in the criminal acts that they are being charged with. In due course, Mr. Presiding Justice and distinguished members of the bench, the prosecution shall seek the indulgence of this honorable court to permit the prosecution of those absent and at large in absentia. The Honorable Presiding Justice and distinguished members of the bench, the incident in Nasir in March 2025, characterized by brutal mass murder in cold blood, inhumane treatment, and total disrespect of the dead, and total disregard of the laws of South Sudan remains unforgettable and regrettable stain in the conscience of this republic. My Lord Justices, the prosecution will demonstrate that these were not spontaneous attacks, but actions of well-organized, well-financed, brutal criminal scheme. A criminal scheme carried out by the accused persons as they incited, organized, abated, financed, and weaponized a militant group, the so-called White Army, to target SSPD personnel, civilians, and undermine the government. My Lord Justices, the prosecution will avail evidence that the White Army did not act independently. They were under the direct command of the fourth accused person, General Gabriel Doblam, Major General Dealing Care, who is at large, and the fifth accused person, Dr. Riek Machar, and financed by the first accused person, Mr. Port Kangchol, and Mampal Duor, the third accused person. The attacks by the White Army were planned, funded, coordinated, and commanded by some of the commanders of SPLA-IO. We emphasize some of the commanders of SPLA-IO. The commanders in Juba coordinating the assault were Lieutenant General Gabriel Doblam and Major General Dealing Care. And on the ground in Nasir, the SPLA-IO officers commanding the White Army were namely the late Torgel Thon, Kang Makana, who is at large, Lieutenant General Peter Thokchuol, Brigadier General Manpinj Pal, Brigadier General Peter Palmut Yaj, Bol Doyak, and Major General Kong Moyang. This means the attacks were executed under the direct orders of the fifth accused person, who is the commander-in-chief of the SPLA forces. The evidence the prosecution will present will establish this clear and undeniable claim and the chain of command. It will demonstrate that the militant White Army operated under the direct command and influence and the strategic direction of the accused persons before you and those at large. My Lord Justices, there is a false narrative that this trial is a political witch hunt against the fifth accused person, Dr. Riek Machar, and the other accused persons. Contrary to this claim, my lords, this trial is about the rule of law. It is about giving justice to the victims. It is about having a closer to the victims, fighting impunity, and setting a new departure that crimes must be punished, that there must be a new chapter of accountability for all, regardless of status. Albeit this, it is inversely an opportunity for the accused persons as well to clear their names. In this commitment to the rule of law, my lords, the accused persons before you are presumed innocent as per our Constitution until found guilty by this competent court. It is to this commitment that this trial is open to the public. Further, my lords, it is to this commitment that the accused is duly represented by a competent defense team. And the Republic of South Sudan is willing and in position, given the nature of the offenses herein, to assign lawyers in addition, if need be, to defend the accused persons. The Honorable Justice and the distinguished members of the bench, the accused persons, Porkang and others, stand charged with treason, concealing treason, subverting the Constitution, insurgency, banditry, terrorism, terrorist financing, mass murder, destruction of protected property, treasury, attacks on United Nations personnel, unlawful seizure of a military garrison, and participation in an organized criminal act. These charges, my lords, are brought under the Penal Code Act 2008, the Anti-Money Laundering and Counter-Terrorist Financing Act 2012 as amended in 2024, the National Security Service Act 2014 as amended in 2024, the SPLA Act 2009 as amended in 2020, and the Geneva Convention Act 2012. The prosecution will provide evidence proving beyond reasonable doubt that the accused persons committed the said crimes, and that the crimes are: 1, a crime of treason. Instead of paying allegiance to the Republic of South Sudan, the accused persons waged war against the state with intention to overthrow the constitutional government contrary to sections 64, 65, and 66 of the Penal Code Act. That the accused persons engaged in terrorist acts. The accused persons committed violence with the intention of causing forcible resistance to the government and to the defense forces and any lawful agencies, as well as possession and using dangerous weapons, contrary to sections 67, 70, 71 of the Penal Code Act. That the accused persons engaged in terrorist financing. The accused persons collected and provided funds with the knowledge that they would be used for terrorist purposes, contrary to section 14, 15, and 16 of the Anti-Money Laundering and Counter-Terrorist Financing Act 2012 as amended in 2024. That they committed mass murder. The accused persons abated the brutal and inhuman killings of armed SSPDF and wounded personnel, including the late Major General David Major Dak, the commander of SSPDF in Nasir, a UN personnel member, and 257 SSPDF personnel in Nasir, in violation of the Geneva Convention and the Penal Code Act, sections 10 and 206, respectively. That they committed as well destruction of protected property by damaging UN-marked helicopters, destruction of military equipment and civilian assets, contrary to Section 67 of the Penal Code Act and the United Nations Convention on the Safety of United Nations and Associated Personnel 1994. And that they committed treachery by consciously giving confidential information to the SPLA-IO commanders on the ground and in Juba, and withholding vital information from the SSPDF command, contrary to sections 64, 1, F, and G of the SPLA Act 2009 as amended in 2022. My lords, in terms of evidence, the evidence will point a picture of calculated violence that extended beyond military targets. It will detail gross violations of the Geneva Convention, including desecration of the dead and persecution of innocent civilians and UN workers. The prosecution will present a layered evidence strategy, beginning with testimonial evidence that will come from survivors, eyewitnesses, and protected witnesses who will recount the attacks, the planning meetings, and the consequences they endured. The prosecution will provide documentary and physical evidence like signed operational orders and autopsy reports. The prosecution, my lord, will provide digital forensic evidence like call records, WhatsApp communications, preserved and authenticated in compliance with international standards and international evidentiary standards. The prosecution as well will present expert testimonies from forensic pathologists, from digital forensic specialists, from military experts that will assist this honorable court in understanding the technical aspects of these crimes. This evidence will be presented chronologically, from the planning to the funding to execution to the aftermath, ensuring that each strand corroborates the other and eliminates reasonable doubt. My lords, the prosecution will meet this with the independent corroboration of witness statements, forensic and biometric evidence, authenticated through metadata, hash measures, hash values, and expert verification. In terms of procedural standards, my lords, the prosecution will assure the court that every exhibit is supported by an unbroken chain of custody. Vulnerable witnesses will be protected, including through in-camera testimony when necessary. In conclusion, my lords, this trial is a testament to our nation's unwavering commitment to the rule of law and to breaking this cycle of violence and impunity. The accused persons have been informed of their rights and their right to fair trial. We operate in a strict adherence to our constitutional standards and our obligations under international law. This trial, my lords, is about accountability, justice, and the rule of law. The evidence will prove that accused persons deliberately conspired to wage war against the state, terrorize civilians, and undermine the peace and security of South Sudan. At the conclusion of this case, my lords, notwithstanding the presumption of innocence of the accused persons before this honorable court, the prosecution shall respectively request conviction on all principal charges and the imposition of sentences proportionate to the gravity of these crimes, consistent with South Sudan laws and international standards. Allow me, my lords, to return the mic to you, if any, for the defense team to exercise their right of reply to our statement, and thereafter to the investigator who shall journey us through the process of demonstrating the evidence that shall be demonstrated before this honorable court to prove the charges against the accused persons. With this, my lords, justices, the prosecution remains appreciative of your patience. I end. Thank you.
Okay. Then the next step is that we go to hear the first witness.
Do they have the defense?
No, they don't have. The law is clear.
I think, Mona, you make an announcement with that.
Thank you, my lord.
Excuse. You know, it's very, very good. You know, while we're going to start, please, if there are witnesses of both parties within the audience in the court, are ordered to go out. If there are witnesses here in the court, let them go out. This is very important because if we discover that there was a witness inside the court listening to all these pleadings, we may not allow him to provide his statement. And also, let me take this opportunity to remind the media, those who are reporting, please stick to the rules of reporting, journalistic reporting. You should not go and start trying to pass your opinions or trying to analyze the facts that are given in the court. Please adhere to the law, to the provision of the law, domestically and internationally.
something.
All right.
أنا داير نقول شنو؟ أي زول بيعتبر نفسه شاهد للدفاع أو للاتهام من فضلك قادر هذا المكان. نحن ما دايرين شهود في هذا الوقت. أي زول شاهد يطلع. شكرا.
Now, let us begin with the first witness of the prosecution. There is no reply, according to the law, that the defense. No, excuse, please, sit down. Let's start with...
My Lord.
Excuse. Sit down until I give you...
My Lord, as you pass decision on the objections which were noticed by the two parties, we in the prosecution team in the position to request Your Honor that this session to be adjourned for tomorrow for verifications, all the exhibits and evidence which in our side to be presented by the investigator. Thank you.
Yes, the defense. What is your reply? Do you have any objection?
Thank you, my Lord. First and foremost, before I indulge to respond to our colleagues in the prosecution, I'm praying from Honorable Court to avail us with a copy of the decision read to us for some minutes. We need a copy.
The opening speech is not given to you?
The ruling of this Honorable Special Court for our objection on point of law. We need a copy.
It's okay. You may be allowed to be given copy.
Thank you.
Whatever you want. But what is your response to the request for the adjournment for tomorrow?
Before I respond to the prayer of our colleague in the prosecution to adjourn this session, we are governed by Act Section 224 of the Code of Criminal Procedure Act, specifically 224 subsection 2, which allow us as defense of the opening speech. We are given also the legal right hearing the defense, evidence of defense to respond to what the prosecution have stated. We are ready. My Lord, Your Lordship, subject defense respond to the public prosecution opening speech. We act for and on behalf of the accused, His Excellency Riek Machar, the first Vice President of the Republic of South Sudan, Put Kang Shol, Lieutenant General Gabriel Dub, Mam Pal Dor, Gadwich Lampoj, Brigadier General Camilo Gadmal Kel, Mading Diar Riak, and Dominic Gadrog Riak, respectively. We submit this response to the opening speech delivered by our colleagues, the public prosecution, as follows. I want to bring the attention of our colleagues that in their opening speech, they just gave us a conclusion without giving us the facts. They have used command, influence, who command who, and who influence who.
Objection, my lord.
Yes.
My lords, based on the section cited, section 222, subsection 2B, that deals with the prosecution opening speech, there is nothing as a right of reply. If he's referencing subsection C, it talks of reply of the accused to the prosecution. That is a state that we have not reached to, because we are supposed to get into the statement of the inquirer, who is the complainant, and the statement of the complainant, if any, and the discussion of the same. What I was expecting is, my lord, based on our procedure, this is a special court. When the investigations were completed, the investigator and the public prosecution took the evidence to the court. But given the sensitivity of the matter, the court then, before the establishment of this court, the Office of the Chief Justice advised that given the sensitivity of these evidences, it should be kept by the prosecution and only be availed before this honorable court on the start of the prosecution case. So what we are expecting, or what we are praying for this honorable court, is we sought an adjournment to allow the prosecution and the investigator to submit to this honorable court the evidence that is available. Because we cannot give it to the court, since the Chief Justice had advised that the special court had not been established, and therefore we must come and submit it to the special court. And we request for this, my lords, in the interest of justice and following our rules of procedure. Thank you.
Yes.
Your Lordship, it seems that the prosecution have forgotten about natural justice. And natural justice, the element of natural justice are two. One, odi altrum patrum, which means do not condemn somebody unheard. Second, nemo judice impropera posa, which means a monkey should not determine the affairs of the forest, which means rule against bias, which is part of Article 19 of our Constitution. The right to be heard is enshrined in the Universal Declaration of Human Rights, 1948. It's also enshrined in the International Covenant for Civil and Political Rights of 1966, read together, International Covenant for Social, Cultural.
Objection, Your Honor.
Please, let him continue.
Are you forgetting our rights?
Please, continue.
We have spoken, and this is my time to talk.
It's okay. Please shorten your response.
Thank you, my Lord.
Yes.
My colleagues, Your Lordship, the prosecution alleges that our clients and 8 accused are guilty of serious offenses under Chapter 4 and 5, Section 206, 239 of the Penal Code, read together with Section 15A, B, and Section 16 of the Money Laundering and Counterterrorism Act 2012 as amended, read together with all the sections mentioned in the charges. To succeed, the prosecution moved from must prove beyond reasonable doubt that the accused person committed each and every element of the alleged offenses unless and until the prosecution discharge that burden, the burden of proof lies on them to certification of this honorable special. The presumption of innocence must prevail. First and foremost, Your Lordship, and before we indulge into the fact and the law applicable, we would like to emphasize on the role of a prosecution attorney, because criminal law or penal court involve a contest between a state and accused person. It is imperative that both sides are represented by competent and ethical advocates or attorneys. The primary duty of lawyers for state prosecution and the accused or defense is to assist the court and the process and not to their respective clients as such. Thus, both sides have essentially similar obligations, although they come to their task from different perspectives. Your Lordship, a prosecution represents the state, not the victim. His or her duty is not to secure conviction at all costs, but to ensure that all the evidence fairly and accurately adduced before the court of law. Your Lordship, a prosecutor is the Minister of Justice who represents the government in the public prosecution according to provision of Article 135, Clause 3 of the Transitional Constitution of the Republic of Sudan, 2011, as amended. The prosecutor principal's role is to assist the court to arrive at the truth and to do justice between a community and the accused person according to law and the dictates of fairness. A prosecutor is not entitled to act as if representing private interest in litigation. A prosecution or a prosecutor represents a community of South Sudan, and not any individual and sexual entity. A prosecutor acts independent, yet in general public interest. The prosecutor interest is to be understood in that context as in historical continuum, acknowledging debts to previous generation and obligation to future generation. Your Lordship, in carrying out that function, it behoved him neither to indict nor on trial to speak for conviction except upon credible evidence of guilt, which credible evidence means believable evidence, reliable evidence, trustworthy evidence, evidence acquired according to law, not unconstitutional evidence or illegal obtained evidence, which will submit to this honorable court in due course. Let me repeat again. In carrying out that function, it behoved him, the prosecution, neither to indict nor on trial to speak for conviction except upon credible evidence of guilt, nor to do even a little wrong for sake of expediency, or to pick any person or please any power, not to be either gullible or suspicious, intolerant or overplanned, as we have realized from our colleagues there. In the firm and abiding mind to do right to all manner of people, to seek justice with care, understanding, and good confidence. They should not be biased to the government. They should be biased to the people of South Sudan. Restore justice in this nation, this beautiful nation of ours. Your Lordship,
My Lord.
it cannot be.
My Lord.
Thank you.
Yes. Let my learned colleague to stick on our opening speech, not to make reflection of what he is in mind, criticize the prosecution. This is not the time for him. Thank you.
It's okay, sit down. Please, please.
Your Lordship,
Doctor, try to summarize, huh? Because we have written...
mine is only 5 papers, and we have done 2, remains 3.
Try to stick to,
Yeah.
to their...
Your Lordship, it cannot be overemphasized that the purpose of criminal prosecution is not to obtain a conviction. It is to lay before a court credible evidence, relevant, related, connected, and linked with the facts. One of the ingredients of the elements of the crime, which all of us, we know in this room, act as rare Menzeria, and Kozesho. We need our colleagues there to stick to these three elements, ingredients of the crime. Menzeria, actus rea, menzeria, and Kozesho, which means physical act, criminal guilt, and connection between the act and the deed and the result. Your Lordship, lawyer has a duty to see that all available legal proof of the fact is presented. It should be done firmly and pressed to its legitimate strength, but it must all be done fair. The role of the prosecution excludes any notion of winning or losing. His function is a matter of public duty than which in civil life there can be none charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense of the dignity, the seriousness, and justice of judicial proceeding. Your Lordship, furthermore, Lord Macmillan, a Lord Advocate General in Scotland, and a member of the Judicial Committee of the House of Lords of England.
Please, Giri, why don't you just give us the paper and then we gain the time instead of...
I'm doing. So this Lord says, we, in the discharge of his office, the advocate has a duty to his client who are here, a duty to his opponent who are there, a duty to the Honorable Court, a duty to himself, to myself, to ourselves, to respect this Honorable Noble Court, and a duty to the state, our country, the Republic of South Sudan. We are here for that. Your Lordship, the accused person prior to their arrest were subjected to politicized media campaign, outrages by ministers, politicians, and senior officers. In that campaign, explicit accusations were broadcast against them. The media broadcast against them to the public. This conduct amounts to unlawful and prior conviction of our accused and a blatant violation of the constitutionality guarantee presumption of innocence, which is stipulated in Article 19, Clause 1 of our beautiful Constitution, read together with Section 6 of the Code of Criminal Procedure 2008 Laws of South Sudan. The accused is innocent until it is proved beyond reasonable doubt. And for our colleague, let me tell you from here, what is the meaning of beyond reasonable doubt?
Gary, please,
Let me conclude.
finally...
Let me conclude. Moreover,
you just try to conclude.
it is just only 3 lines. Moreover, the defense records are...
Excuse me, Dr. Giri. You must know that Section 224 doesn't give you the right to respond. And we allow you to do that simply so that you enrich the procedures. Please try to summarize. Otherwise.
Thank you. I want to remind this Honorable Court that South Sudan belongs to common law and judges always make law in the absence of procedural fair. We have to do that to our country. Moreover, the defense records that the investigative authorities proceeded to arrest, interrogate unlawful search, and charge the accused person before their constitutional immunity had been duly lifted, and only thought to cure this defeat respectively. This violates the principle of legality, as a principle firmly recognized in our jurisprudence that what is built upon illegality remains invalid. It is null and void, ab initio, ad limine, from the beginning. Any such without due process of our Code of Criminal Procedure to our clients here are considered to be null and void, ab initio. Your Lordship, in addition, this case has placed the government in a position of embarrassment. It has been brought forward without proper official rights and without the request procedural foundation. This has left the public prosecution exposed to the extent that it risks withdrawal. This scenario mirrors a well-known precedent in which their late colleague, distinguished counsel, our late colleague, Charles Deng, our brilliant lawyer of this country, who passed on. He rejected to represent the government in the case of Asma Mahmoud, Mohamed Taha, and others versus government of Sudan in is published in the Sudan General Report 1986, where it was affirmed that the prosecution cannot sustain a prosecution in the absence of proper legal foundation. Honorable Justice of this Honorable Special Court, justice is neither proclaimed from political podiums nor declared in security offices. Justice is dispensed in the courtroom, beautiful courtroom like this, such as this special court under the rule of law. And the rule of law, our professor, Albert Van Dicey, has come with his book about that.
I give you 2 minutes to finish your speech.
Thank you. Your Lordship, a matter of fundamental importance arises in this proceeding, namely the manner in which the prosecution intends to establish that accused person is standing before this special court are responsible for alleged crime, of which crime scenes in Nasir, in the Upper Nile State. It is undisputed fact that the said location is situated at a distance approximately 712 kilometers from the city of Juba, where all these are here, and Nasir is far. How they manage, they fly up to there and come. We don't have transport from Juba to Nasir. We don't have a road. How they manage to go there, the burden of proof lies on he who alleges to prove the case beyond reasonable doubt. Your Lordship, the accused person had been detained since March 2025 up to 21 of September 2025 in a clear violation of their constitutional right. A person arrested by the police as part of investigation may be held in detention for a period not exceeding 24 hours, and if not released on bond, to be produced in court according to provision of Article 19, Clause 4 of our beautiful Constitution of Republic of South Sudan. Number 2, every person shall have the right of a fair and speedy trial, and justice shall not be delayed pursuant to provision of Article 122, Clause 5, Paragraph B of the Constitution, our Constitution, read together with the provision of Section 6A of the Code of Criminal Procedure Act 2009. Number 3, every accused person is presumed innocent until his or her guilt is proved beyond reasonable doubt in accordance with the provision of Article 19(1) of the Transitional Constitution 2011 as amended, read together with the provision of Section 6P of the Code of Criminal Procedure. Number 4, no punishment shall be inflicted upon any person exceeding the prescribed by the law in force at the time such offense was committed. The prosecution operating in speech is filed with political rhetoric and general description lacking material evidence, real evidence, and the legal element of alleged crime. In conclusion, because to conclude I must, we will respectfully invite your Honorable Special Court to render the 8 accused person not guilty of any crime. Thank you.
Okay. It's good to when a written
موجود.
أشكر فضل.
لقد تقدم الأستاذ مولانا دين تسجيل ممثل الاتهام بتأجيل جلسة يوم غد الثلاثاء. إننا في الدفاع نعترض على الطلب الذي تقدم به ممثل الاتهام للآتي من أسباب: واحد، لقد ظل سيف الاتهام سلط على رقاب المتهمين منذ نهاية مارس 2025 إلى يومنا هذا، ولقد أخذ الاتهام بإجراء التحقيق والقبض والحجز لأكثر من 6 أشهر. إننا وفي اعتقادنا المتواضع لا نرى مبررا يستدعي تأجيل هذه الجلسة. علينا نلتزم المحكمة الموقرة رفض طلب الزميل والاستمرار وسماع المتحري.
Thank you, my lords. We all agree that this case has taken long, and in the interest of justice, it should move very fast. However, there are procedural requirements that we cannot jump, and that is providing this court our evidence. So we are requesting this adjournment not because we don't want to proceed. We want to proceed, but the requirement is that we must submit this evidence to court, so that it will be in the custody of court as we proceed with the court proceeding. It is our right as well to request for the same. So we insist on our prayer for adjournment so that we proceed tomorrow in the morning after submitted and verifying with the court police all the evidence that should be submitted to the court. It is not our own making, but it's because of the speciality of this court, the nature of this court, the uniqueness of this court. If this court was existing on its own before, we would have done this long before today. Thank you.
You see, it is for these reasons we allow even the defense to respond, while we are aware that Section 124 doesn't give the defense the right to respond. This is number one. Number two, we agree with the request because each and every party is supposed to give evidence in a thorough manner. Therefore, the session is going to be adjourned up to Wednesday after tomorrow. Thank you.
My Lord.
Go!